Bismillahirrahmanirrahim. Okay guys, we were discussing about the chapter of examination of witnesses. In that chapter we discussed about the scope, limitations and jurisdiction of cross-examination, examination in chief, leading questions and re-examination. In that particularly our main emphasis was on the cross-examination. We discussed which type of questions can and cannot be asked during cross-examination by the advocate of a witness of a party. So we will continue with that. Today I am going to start with Article 149, which states so, when a witness has been asked and has answered any question which is relevant to the inquiry only insofar as it tends to shake the credit of witness by injuring his character, no evidence shall be given to contradict him, but if he answers falsely, he may afterwards be charged with giving false evidence. Okay, you have asked a question which was basically intended to shake the credit of the witness, to test his veracity, to prove his untruthfulness, and you ask this question. So whatever answer the witness will give you to that question, you are bound to accept that answer. You cannot afterwards contradict that witness on the basis of the answer which he or she has given to your question. You have to accept that answer. So you don't have any other option in this regard. So what option you have got? Okay, you cannot contradict, but if you think that the answer which the witness has given to your question is basically false and it is not according to the truth, according to the facts, you may launch a separate case against that witness for giving false evidence, for perjury, okay, for, in court of law. But as a matter of fact, you cannot contradict that witness on the basis of answer which he or she has given to your question. And what type of question? The question which is intended to check the veracity of the witness, the question which was intended to shake the credit of the witness. You cannot contradict him or her on the basis of the answer which he or she has given in answer to your question. So number one, and this is the thing. But there are some exceptions to this general rule. For example, exception number one is that if a witness is asked whether he has been previously convicted of any crime and denies it, evidence given may be given of his previous conviction. If the question which has been asked by the advocate is specifically related to the criminal history of the witness, and it is asked that whether you were habitually involved in commission of these type of offenses in the history, in like last 10 years, 5 years, you have been convicted for committing theft like 10 times before, or dacoity or murder, and in response to your this type of question, the witness says, no, I was not part of any type of these illegal or criminal activities before. Instead, I got very good character in the society. So in response to these type of questions which are basically related to the previous convictions of a witness, and if the witness answers no, in these type of cases, yes, you can contradict the witness there in the court, okay, and you can bring any other evidence contradicting the answer, the evidence given by the witness, and proving that the witness is not trustworthy and he is not speaking a truth in the court. So this is the exception. So what was the general rule? What the general rule was that if the question is intended to shake the credit of the witness, so whatever answer he or she will give, we will accept that and we will not contradict him. And what is the exception number one? Exception number one is that if the question is specifically related to the criminal history of a witness, and if the witness does not reply in a truthful way, the advocate has got right to contradict him there, just in front of the court in that particular instance. Then the exception number two comes, which states that if a witness is asked any question tending to impeach his impartiality and answers it by denying the facts suggested, he may be contradicted. So number one was that the previous criminal history of a witness, and number two is about the impartiality. if the advocate, if the question is related to the veracity of the witness, to shake the credit of the witness, and in that category, the subcategory of the question is that the question is being asked just to check the impartiality of the witness, whether it is partisan towards any party, the party which is calling him or her to give evidence on his behalf, or he or she is a neutral person. So basically the objective of the question is to establish the partiality or impartiality of the witness, and in that context the question is asked, and which is challenging the impartiality of the witness, and the witness states that, no, okay, look, I'm a very much neutral person, I don't have anything to do with the plaintiff or the defendant, with the complainant or the respondent, I have nothing to do with this property, with this commodity, with this movable or immovable property, and I'm a neutral person and I'm a respectable citizen of the society, so you cannot question my credibility, my impartiality. So you can basically contradict him or her on this part, on this topic as well, when the question is specifically related to the impartiality of the witness. So now we would move to Article 150, which states so, questions by party to his own witness. So sometimes it happens so that you have called a witness to give evidence on your behalf, he was or she was an attesting witness to your document, to your contract, to your agreement of mortgage, of sale, of tenancy, or so and so. But you are thinking that the witness is impartial, he is a fair witness, he will speak truth in the court. But when you produce that witness in the court, you found that the witness is hostile. There could be multiple reasons for this hostility. You may have any personal grudge, any personal enmity, undeclared and undisclosed with him. You are thinking that, okay, we are normal, but the other person, the witness you are producing on your behalf, he or she may have any grudge related to you. So when you approached him, he consented to give evidence in the court, but as a matter of fact, when you bring him or her in court, the witness is hostile. Another reason may be that he may have been intimidated by the adverse party, that, okay, if you stated so and so in the court against me, I will see you, I will see your kids, I will see your family. There may be inducement as well by the adverse party. You are thinking that I am producing this witness on my behalf, but as a matter of fact, the witness has been approached by the adverse party and he has been induced any type of lucrative benefit or advantage in terms of money, or in terms of money, or in any other way. He may have been offered like 5 lakh, 10 lakh for giving a specific evidence in the court. There can be promise as well. There can be question, as I talked about it before. So there could be multiple reasons that you produced a witness thinking that, okay, this witness is fair, impartial, and he will speak truth in court. But as a matter of fact, the witness has been hostile against you. So in your examination in chief, this has been disclosed in the court that, okay, the witness is basically hostile. So in this context, the law of evidence, the Kanun-e-Shahadat order, is giving you right that if you think that the witness is hostile, the cross-examination, which was basically a tool which was provided for the adverse party's advocate, that tool will also be provided to you then as well. You can cross-examine that witness which has been produced on your behalf, as about whom you are thinking that he or she is a hostile witness now. So you can cross-examine him, you can test his veracity, you can establish his falsehood, his untruthfulness in the court, his hostility towards you, the reasons for that hostility. You can establish all these things in the court of law. words, I would move to Article 151 of Qanun-e-Shahadat order, which is related to impeaching credit of witness, which states that the credit of a witness may be impeached in the following ways: by the adverse party or with the consent of the court by the party who calls him. Number one. So we talked about a lot about the shaking the credit of the witness, about checking the veracity of the witness, about proving and establishing the falsehood, the untruthfulness of the witness in the court, to prove his lies in the court. So what are the possible ways to do so? How you can establish, how you can check, how you can confront the veracity of a witness? So these ways has been provided by Article 151 of Qanun-e-Shahadat order, which states that you can check the veracity of a witness by the evidence of persons who testify that they, from their knowledge of the witness, believe him to be unworthy of the credit. On that witness, you can bring some other witnesses who states in court that we, from our own knowledge and skill of the whereabouts of this person, this witness, of his community, of his family, of his society, being his friend, being his neighbor, being his colleague, being his being his mate, we know that this person is unworthy of credit. He is not a truthful person. He has been found many times guilty of misconduct, biasness, and speaking lies. So this is one of the ways that you produce a witness who states so that, okay, I know from my own knowledge, being his business partner or being his neighbor or so, that this person is unworthy of credit. The court shouldn't rely on the evidence produced by this witness. Number two, this can also be established by proof that the witness has been bribed. As I talked about it earlier in the hostility of a witness, if the witness is hostile, you can prove that, okay, look, the witness has been bribed by the adverse party against whom you were intended to produce this witness, and this is the evidence of this bribe, or has accepted the offer of a bribe, or has received any other corrupt inducement to give his evidence. Number three, by proof of former statements inconsistent with any part of his evidence which is liable to be contradicted. You can also establish the falsehood, the unworthy of credit of the witness in the court by contradicting his statement extracted by him in the current case, by relating it, by corroborating and contradicting this current statement with his previous statements about the same subject matter which he has been given during a discussion, during an audio video recording, or during any type of writing, or in front of some persons, or in any other judicial proceeding, or in any inquiry. So as a matter of fact, basically you can contradict his statements, the current statement which he is giving in this case in hand, and his statements he has given before at any other forum, in a court, in a commission, in inquiry, or while sitting in his friends and family, or which is established by his writings, his text messages, his emails. So basically you can contradict these two contents on the same subject matter, and in this way you can establish that this person is a lie, and he or she is not speaking truth in court. Number four, when a man is prosecuted for rape or an attempt to ravish, it may be shown that the prosecutrix was of generally immoral character. In cases of rape, you can prove the previous bad character of the witness who is giving evidence in a court of law in case of rape, and his own moral character related to this particular offense, his own track record is bad. So a reasonable apprehension and presumption is attached to the matter that, okay, because this person on his own, he doesn't have a good character, so there is reasonable ground to believe that he will not speak truth in this regard in this case of rape in court of law. So in cases of rape, you can previous the illicit and bad character of a witness related to rape in court of law, and in this way you can shake the credit of the witness. Then comes the explanation. A witness declaring another witness to be unworthy of credit may not, upon his examination in chief, give reasons for his belief, but he may be asked his reasons in cross-examination, and the answer which he gives cannot be contradicted, though if they are false, he may afterwards be charged with giving false evidence. So that's all today for today's lecture. You will look into this explanation and the illustrations which has been provided at the end of this article, I would be going to assign an assignment to you guys as well, because your final term examination is just around the corner. We are expecting it in the next month in July. So I would also remind you all to please get ready for that as well. And if you got any type of answer, if you are feeling any difficulty in understanding these things, please let me know through your text messages, your email, or your WhatsApp, and I would try to address those questions up to the maximum of my knowledge and information. Thank you very much.